The clock on the microwave read 6:42 a.m. when I saw the yellow truck. It was a big, brutish thing. A flatbed with a knuckle-boom crane folded onto its back like a sleeping metal insect. It was idling just past the line of ancient oaks that marked the unofficial boundary of my property, its diesel engine putting a low, guttural tremor into the morning air that I could feel through the soles of my slippers. I stood at my kitchen window, a cup of black coffee warming my hands, and watched as a second vehicle, a mud-splattered pickup, pulled up behind it. From the passenger side emerged Brenda McNamara. She was dressed for a campaign rally, not a demolition. She wore a bright pink blazer over a white blouse, crisp linen trousers, and shoes that were entirely unsuitable for the damp, grassy verge. She gestured with a sweeping, imperious arm toward my barn. My barn. The man in the driver's seat of the yellow truck, a heavy-set fellow in a high-visibility vest, nodded slowly, his expression impassive. He looked like a man who was paid to follow orders, not to ask questions. Brenda pointed again, jabbing her finger through the air, as if trying to physically impale the building with her sheer force of will. I took a slow sip of coffee. It was hot, bitter, just right. I set the mug down on the granite countertop, picked up my phone, and started recording. I didn't zoom in. I didn't need to. I wanted the wide shot. I wanted the yellow truck, the muddy pickup, the line of oak trees, the dew-soaked grass of my own lawn, and Brenda, a garish splash of pink against the soft greens and browns of the early morning, standing unequivocally on my side of that line. She took a few more steps, her entourage of 2 men from the truck following, and stopped near the old stone foundation of the barn. I slid open the patio door. The sound was a low rumble, but in the quiet of the morning, it was enough. Brenda's head snapped in my direction. A wide, predatory smile spread across her face. This was what she wanted, a confrontation, an audience. "Arthur," she called out, her voice a little too loud, a little too cheerful. It was the voice she used at the homeowners association meetings right before she announced a new special assessment. "So glad you're awake. We were trying not to disturb you, but since you're up, this will be much easier." I said nothing. I just stood there in the doorway, the phone held steady in my hand, its small red recording icon a silent, blinking witness. Her smile faltered for a fraction of a second. She preferred a back and forth. She thrived on argument. My silence was like a vacuum, and she rushed to fill it with words. "As you know, the Architectural Review Committee has repeatedly cited this structure," she said, waving a dismissive hand at the barn. "It's a clear violation of Section 9, subsection B of the community bylaws. Dilapidated outbuildings are not permitted. It's an eyesore, and it's dragging down everyone's property values." The 2 men with her shifted their weight. One of them glanced at the barn, then at me, then back at the barn. He looked uncertain. The other just stared at the ground. They were tools, and their wielder was getting agitated. "The board held a special vote," Brenda continued, her voice gaining a sharp defensive edge. "It was unanimous. We're exercising the association's right to remedy the violation and billing the cost back to you. We've hired this company to remove the hazard. They're giving us a very good rate, so you should be grateful." She crossed her arms, a posture of final, unassailable authority. "So, if you'll just step aside, we can get this done before breakfast." I lowered the phone slightly, making sure it was still capturing her face, her posture, her presence on my land. I took a deep breath, the cool, damp air filling my lungs. I thought about the files in my office, the meticulously organized binders, the color-coded tabs. I thought about the certified letters she had ignored, the public records she had never bothered to check. I thought about my late wife, Eleanor, and the summer we spent carefully restoring the barn's original post and beam frame. I thought about the weight of history, both the barn's and my own. She had no idea. She stood there in her pink blazer, a petty tyrant on a 10-acre kingdom of manicured lawns and identical mailboxes, and she had absolutely no idea what she had just done. She hadn't just trespassed on my property. She hadn't just threatened a building. She had, in her boundless arrogance, kicked open a door that had been patiently waiting for her for 5 long years. She thought she was demolishing a barn. She was wrong. She was demolishing herself. But before I tell you what I did next, standing there in my slippers on a cool Tuesday morning, I should probably explain. To understand the weight of that moment, you have to understand the weight of the years that came before it. You have to understand the barn, you have to understand Brenda, and you have to understand me. My name is Arthur Pendleton. I am 72 years old. For 45 years, I was a land use attorney. That's a polite term for a lawyer who spends his life in dusty county archives, poring over 100-year-old deeds, zoning maps, and easement agreements. My job was to know who owned what, where the lines were drawn, and what the rules said. Not what people thought the rules said, or what they wished the rules said, but what they actually legally, bindingly said. It's a profession that rewards patience and punishes assumptions. It grinds you down to a fine powder of pure, unadulterated fact. Emotion has no place in a title search. A survey stake doesn't care about your feelings. I retired 6 years ago, a year after my wife, Eleanor, passed away. We bought this property 30 years ago. It was the original homestead of the Miller family, a 10-acre plot with a small 1880s farmhouse and the barn. The barn was the real prize. It was a classic 3-bay English-style barn, built around 1850, with hand-hewn hemlock beams and a fieldstone foundation that felt like it had grown out of the earth itself. Eleanor was an amateur historian, and she fell in love with it instantly. For her, it wasn't a dilapidated outbuilding. It was a physical link to the past, a story written in wood and stone. About 15 years ago, the 90 acres of farmland surrounding our property were sold to a developer. That's how the Creekwood Estates Homeowners Association came to be. We fought the development, of course. We argued for larger lot sizes, for preserving more of the open space. We lost. But we did secure one crucial concession in the master plan. Our original 10-acre lot, the Miller Homestead, was to remain independent, an island in the sea of cookie-cutter executive homes. We were not required to join the HOA. We were not subject to its bylaws. It was all there, in black and white, in the master deed filed with the county. On paper, we lived peacefully for years. The new neighbors were mostly fine. They had their perfectly green lawns and their identical black mailboxes, and we had our wildflower meadow and our slightly crooked historic one. Then 5 years ago, Brenda McNamara and her husband bought the house directly across the street from us. And Brenda, it turned out, was a joiner. More than a joiner, she was a ruler. Within a year, she had maneuvered her way onto the HOA board. A year after that, she was its president. Brenda's reign began subtly. A friendly newsletter reminder about bringing in your trash cans on the day of pickup. Then it escalated. Official notices of violation for grass that was 1/4 of an inch too high. Fines for leaving a child's bicycle on a driveway overnight. She had a particular obsession with uniformity. Any deviation from the bland beige aesthetic dictated by the CC&Rs was treated as a personal affront. She would patrol the neighborhood in her oversized SUV, a clipboard on her passenger seat, taking notes. I watched it all from a distance. I was not a member of her little kingdom, so I was for a time invisible to her. But I saw the fear she instilled. I saw my neighbor to the left, a young family, receive a $200 fine because their daughter had used sidewalk chalk on their own front walk. I saw my neighbor to the right, a widow named Mrs. Gable, get a citation for her garden gnomes. Brenda claimed they were unapproved lawn ornaments, and I started a file. It was professional habit, I suppose. When you see a problem developing, you start a paper trail. The first thing that went into the folder was a copy of our deed and the master plat for Creekwood Estates, with the exclusion of our lot highlighted in yellow, the foundation of any good case. Then I started documenting. When Brenda sent a blistering email to the entire community listserv castigating someone for putting their recycling out too early, I printed it and filed it. When she had a shouting match with Mr. Henderson over the color of his azaleas, he claimed they were pink, she insisted they were an unapproved shade of magenta. I made a note of the date, time, and substance of the argument. Then, about 3 years ago, her gaze fell upon me, or rather upon my barn. She sent me a letter. It wasn't an official HOA notice, because her own management company had likely told her I wasn't a member. It was a friendly letter from a neighbor. It suggested the barn was in disrepair, and that I should consider having it torn down for the good of the community. I wrote back a polite, 1-sentence letter. Thank you for your concern, but the barn is structurally sound and historically significant. I sent it via certified mail. I kept the receipt. I filed a copy of my letter and the green signature card when it came back. That's when she decided to invent a new reality. She began telling people I was a legacy member of the HOA, a property that had been grandfathered in, but was still subject to the aesthetic and safety rules. It was complete fiction. But Brenda had a talent for repeating a lie so confidently and so often that it started to sound like the truth, at least to people who didn't want the hassle of questioning her. She started sending me official-looking notices from the HOA. Notice of violation, unapproved outbuilding, final warning, failure to comply. They were masterpieces of bureaucratic intimidation, citing bylaws that didn't apply to me, levying fines I had no obligation to pay, and I paid every single one. I wrote a check from my personal account made out to the Creekwood Estates HOA. In the memo line, I wrote payment under protest for baseless fine, lot 0. I mailed the check and I kept a copy of the canceled check when it cleared. Each check was another thread in the web I was weaving. Each cashed check was an admission by the HOA that they were taking money from a non-member for a fabricated violation. It was beautiful. It was a paper trail of their own malfeasance, funded by me. I kept the receipts. I kept every threatening letter, every nonsensical fine notice. I had a binder now, 3 inches thick, with dividers for correspondence, illegal fines, neighbor testimony, and governing documents. It was a work of art, a monument to methodical patience. The barn itself was another matter. After Eleanor passed, maintaining it became my way of keeping her memory alive. It was not dilapidated. Far from it. A decade prior, working with a state historical preservation grant that Eleanor had applied for, we had the entire structure professionally assessed. We had the foundation repointed, the roof replaced with period-appropriate cedar shakes, and several of the main support beams reinforced with hidden steel brackets. The report from the structural engineer, which I had in my files, declared the barn sound and stable for another 100 years. And more importantly, as a condition of the grant, we had the barn formally listed on the State Register of Historic Places. It wasn't just my barn. It was Landmark 734. Its status was a public record, clearly noted on the county tax maps and the official property plat. Destroying or significantly altering a designated state landmark without a permit from the State Historic Preservation Office is a Class A misdemeanor in this state. It carries fines of up to $10,000 per day and potential jail time. This, too, was a fact Brenda was spectacularly uninterested in. She saw an old barn. She saw a nail that refused to be hammered down. She saw a challenge to her authority. The facts of the matter, the law, the deeds, the history, were just inconvenient details to be bulldozed, literally as it turned out. So that morning, as I stood in my doorway, I knew everything that was about to happen. I had been preparing for this exact moment for years. Brenda thought she was bringing the full force of the HOA down on me. She had no idea she was stepping into a meticulously prepared legal kill box. She had no idea that her every move was not just anticipated, but desired. She had built her kingdom on a foundation of bluster and intimidation. I had built my case on a foundation of paper, and paper, as I was about to demonstrate, is stronger than stone. I took a single step out onto my patio, the cool flagstones a shock to my bare feet. I held the phone up again a little more obviously this time. "Brenda," I said, my voice calm and even, "I need you to state your name and your official position for the record, please." Her eyes narrowed. This was not the script she had imagined. "What? Your name and your position," I repeated, just as calmly. "I am recording this interaction, as you are currently trespassing on my private property." "This is not your private property," she sputtered, her voice rising. "It's part of the community. I am Brenda McNamara, president of the Creekwood Estates Homeowners Association. And this," she jabbed a finger toward the barn again, "is a community-approved safety action." "Thank you," I said. "And the name of your company?" I asked, looking at the lead demolition man. He looked nervously at Brenda. We're Johnson Demolition." "Thank you, Mr. Johnson," I said. "Please be advised that you are currently trespassing. The structure you have been contracted to demolish is State Historic Landmark number 734. Proceeding with this action will make you and your company party to a criminal act under state law. I am now asking you and your crew, and Ms. McNamara, to leave my property immediately." The effect of the words criminal act was immediate. Mr. Johnson took a half step back. His partner's eyes went wide. Brenda, however, just laughed. It was a shrill, ugly sound. "Landmark, you can't be serious. You forged some papers and now you think you can stop us? That's hilarious, Arthur, truly. But we have a contract. We have a board vote. You have nothing." She turned to Mr. Johnson. "Don't listen to him. He's just a crazy old man. Proceed with the demolition." Mr. Johnson hesitated. He looked at my phone. He looked at my calm, unblinking face. He looked at Brenda's furious, blotchy one. He was a man caught between a rock and a hard place, and he was starting to suspect that I was the rock. "Ma'am," he said slowly, If what he's saying about this being a state landmark is true, it's not, she shrieked. He's lying. I am the president of the HOA. I am telling you to do your job. This was the point of no return. This was the moment I had been waiting for. The moment she gave a direct order, on camera, after being explicitly warned of the legal consequences. It was perfect. I lowered my phone. I've heard enough, I said, my voice still quiet. I have documented your threats, your trespass, and your conspiracy to commit a crime. You have one final chance to leave before I call the sheriff. You call the sheriff, she shot back triumphant. Go ahead, I'll call them myself. I'll tell them how you're threatening these poor men and refusing to comply with a legal HOA directive. They'll escort you away. She pulled out her own phone, her fingers stabbing at the screen. Excellent, I said. I'll wait. I turned, walked back inside, and gently slid the patio door shut. I went to the kitchen counter, picked up my coffee mug, and took a long, satisfying sip. Through the glass, I could see her on the phone, pacing back and forth on my lawn, her voice a shrill, angry buzz. She had taken the bait. She had done exactly what I knew she would do. The wheels of a slow, methodical, and utterly inescapable justice had begun to turn, and I had all the receipts. While Brenda was performing her aria of indignation for the 911 dispatcher, I made a few preparations. I walked into my home office, a room lined with books on law and history. I went to the large, four-drawer filing cabinet in the corner. I opened the second drawer, labeled Property, and pulled out a thick three-ring binder. The spine was neatly labeled, HOA v. Pendleton, ongoing. I placed the binder on my desk. I opened it. The first page was a table of contents, typed and cross-referenced. Section 1, Governing Documents. Section 2, Correspondence. Section 3, Financial Records, Illegal Fines. Section 4, Photographic and Video Evidence. Section 5, Legal Precedents and State Statutes. It was my life's work applied to my life. From Section 1, I removed 2 documents. The first was the original deed to my property, showing the transfer to my wife and me 30 years ago. The second was a copy of the Creekwood Estates Master Plat Map, filed with the county registrar. I used a red pen to draw a neat, clean circle around Lot 0, my lot, and the explicit notation next to it, not subject to Creekwood Estates covenants, conditions, and restrictions. From Section 5, I removed a printout of the State Historic Preservation Act, Chapter 273 of the State Code. I used a highlighter to mark the specific passage detailing the penalties for unauthorized alteration or demolition of a designated landmark. I took these 3 pieces of paper, placed them in a simple manila folder, and walked back to the front of the house. I could hear the distant sound of a siren. Brenda stood by the road now, arms crossed, tapping her foot, a look of smug anticipation on her face. She thought the cavalry was arriving for her. She had no idea. A sheriff's department SUV rolled to a stop. A deputy stepped out. A young man with a calm, professional demeanor. His name tag read Miller, a pleasant irony. Brenda immediately descended upon him. "Officer, thank God you're here," she began, her voice thick with manufactured distress. "This man, Arthur Pendleton, is refusing to allow these workers onto the property to remove a dangerous, dilapidated structure. He's been threatening us. The HOA has declared it a hazard, and he's being completely irrational." Deputy Miller listened patiently, his head tilted slightly. He let her talk for a full minute, his eyes occasionally flicking from her animated face to my quiet house, to the stoic demolition crew, to the barn itself. When she finally paused for breath, he turned his gaze to me as I stepped out my front door. "Sir," he said, his voice neutral, "can you tell me what's going on here?" I walked slowly down my front path, holding the manila folder. "Good morning, Deputy," I said. "My name is Arthur Pendleton. I am the owner of this property." I handed him the folder. "The woman who called you is Brenda McNamara. She and these gentlemen," I nodded toward the crew, "are trespassing." He opened the folder. He looked at the deed first, his eyes scanning the legal description, the names, the dates. Then he looked at the plat map. I watched his eyes trace the red circle I had drawn. I saw the flicker of understanding. He looked up from the paper, at the expansive lawn Brenda was standing on, and then back at the map. He was connecting the dots. Brenda was not on community property. She was on my property. "Ma'am," he said, turning back to Brenda, his tone shifting from neutral to something cooler. "According to this official plat map, this entire parcel is not part of the Creekwood Estates HOA." Brenda scoffed. "That's a fake. He printed that off the internet. I am the president of the HOA. I think I know what property we govern. This has a county registrar's stamp on it, ma'am. Deputy Miller said, his voice flat. He then looked at the third document, the printout of the state law. He read the highlighted section. He read it again. He looked over at the barn, a new appreciation in his eyes. He looked back at me. Sir, he said, is the barn a designated landmark? Yes, Deputy, I said. State Historic Landmark number 734. The designation is a public record, filed with the state and the county. Ms. McNamara has been formally notified of this fact in writing, via certified mail, on 3 separate occasions over the past 2 years. I have the receipts. I didn't need to show him. The statement was enough. The deputy closed the folder and handed it back to me. He took a deep breath. Ma'am, he said to Brenda, you and your contractors need to leave this property immediately. What? You're taking his side, she shrieked. Did you see the state of that thing? It's a menace. Ma'am, he said, his voice now hard as iron. What I see is a property dispute. That makes it a civil matter. However, you are currently on private property against the owner's wishes. That is trespassing. And if what he says about this barn's legal status is true, you and your crew were about to commit a serious misdemeanor. So, for your own good, I am ordering you to remove yourselves and your vehicles from this property now. He turned to Mr. Johnson. You heard me. Pack it up and go, mister. Johnson did not need to be told a third time. He nodded quickly. Yes, sir, officer. He and his man turned and walked briskly back to their truck, eager to be away. Brenda was speechless. Her face was a mask of pure, unadulterated fury. Her whole performance, her entire reality, had been dismantled in under 5 minutes by a man with a folder. She glared at me, her eyes promising retribution. Then she spun on her heel and stomped back to her pickup truck, slamming the door so hard the vehicle shook. The yellow demolition truck started its engine with a roar, and a minute later, they were gone. Deputy Miller watched them go. He turned back to me, a small, weary smile on his face. Looks like you have things well in hand, Mr. Pendleton. I try to be thorough, Deputy, I said. Thank you for your professionalism. Just doing my job, he said. For what it's worth, that's a beautiful barn. He then tapped the small body camera on his uniform. This whole interaction has been recorded, sir. If you need a copy of the report for your records, it'll be available in a few days. Just reference today's date and this address. I will, I said. I most certainly will. He gave a curt nod, got back in his SUV and drove away, leaving me alone in the quiet morning. The only sound was the chirping of birds in the old oak trees. The crisis was over, but the war had just begun. I walked back inside and went to my office. I opened the binder again. I took out the documents I had shown the deputy and slid them back into their plastic sleeves. Then I went to the evidence section and made a new entry on the log sheet. October 5th, 7:15 a.m. Visit by Sheriff's Deputy Miller. Report. I left a blank to be filled in later. My phone buzzed. It was a text from a number I didn't recognize. This is Janice from the HOA board. I saw what happened. I think we need to talk. The first crack in the dam. I sat down at my desk and got to work. My first call was not to a lawyer, but to my old paralegal, David. David had worked with me for 20 years before I retired. He was younger, sharper with technology, and knew my methods inside and out. He now ran his own legal research firm. Arthur, he said, his voice warm. To what do I owe the pleasure? Don't tell me you're unretiring. Not exactly, I said. I have a personal project. It's a matter of property law and corporate malfeasance. Are you available for some freelance work? For you, always. What's the target? A homeowners association, I said. Creekwood Estates. I gave him the address and the name of the president, Brenda McNamara. I'm sending you a drive with my preliminary files. I have deeds, plat maps, correspondence, financial records. What I need you to do is a full deep dive. I want to know everything about this HOA, its formation documents, its tax status, its insurance policies. I also want a complete workup on Brenda McNamara. Property ownership records, previous addresses, any litigation she's been involved in. Personal or corporate. Sounds juicy, David said. Is this the one you live in, or next to? Next to, I corrected. That's the central point of the dispute. They believe they have jurisdiction over me. The plat map says otherwise. But I don't want to just win on that point. I want to dismantle their entire argument, brick by brick. I want to be over-prepared. The Pendleton method, he chuckled. Scorched earth via paper trail. I'm on it. You'll have a preliminary report by the end of the day. After I hung up with David, I responded to the text from Janice. I am available to speak at your convenience, I wrote. A minute later, my phone rang. Janice's voice was nervous, hushed. Mr. Pendleton, I'm so sorry to bother you. I'm on the HOA board. I live at the end of the cul-de-sac. It's no bother, Janice. Thank you for reaching out. I saw the sheriff, she said, her words tumbling out. I saw the demolition truck leave. Brenda is. She's losing her mind. She's already sent out 3 emails to the board, calling for an emergency meeting tonight to authorize legal action against you for obstruction. That's to be expected, I said calmly. You don't understand, she said, her voice dropping lower. I voted against the demolition contract, me and one other board member, Tom, but she bullied the other 2 into voting with her. She told them your claims about the barn being historic were a lie. She said she had an engineer's report that said it was a hazard. Did she present this report? I asked, my pen hovering over a fresh legal pad. No, Janice admitted. She just said she had it. She said it was ironclad. She does this a lot. She announces a decision has been made and just strong arms everyone into agreeing. Most of us are just neighbors. We don't want the fight. But this different. It felt wrong. I tried to warn her that she should get a real legal opinion before hiring that crew. And what did she say? There was a pause. She said, and I quote, "Lawyers just complicate things. We have the authority under the bylaws, and that's all that matters." She said spending money on a lawyer would be a waste of HOA funds. I wrote it down verbatim. Janice, I said, would you be willing to sign an affidavit to that effect? Another pause, longer this time. I could hear her breathing. What would that mean? It would mean putting what you just told me into a formal sworn statement. It would be evidence. Evidence for what? For the lawsuit I will be filing against the Creekwood Estates HOA and Brenda McNamara personally for damages, conspiracy, and attempted destruction of private property. The silence on the other end of the line was absolute. I think I might have broken her. I don't know, she finally stammered. She'll come after me. She'll make my life a living hell. She's already doing that to many of you, isn't she? I asked gently. The fines, the citations, the public shaming. The only way to stop a bully is to stand up to them. But you don't have to do it alone. I need to think about it, she said. Of course, I replied. Take your time. But Janice? I would advise against attending that emergency meeting tonight. Or if you do, record it. I hung up the phone and leaned back in my chair. Janice was the disillusioned insider. She was scared, but she was on the verge of breaking. Now I needed to find the fearful ally. I had a good idea who it might be. Arthur Henderson was a retired school teacher who lived 2 houses down. He was a gentle soul whose passion was gardening. Brenda had been tormenting him for years. First it was the azaleas, then it was the unapproved bird bath. Last year she had fined him $300 because his wind chimes were, in her opinion, a noise nuisance. He had paid it just to make her go away. I walked down the street later that afternoon. It was a beautiful autumn day, the leaves just starting to turn. Arthur was in his front yard, meticulously trimming his rose bushes. He saw me coming, and a worried look crossed his face. In Creekwood Estates, a neighbor approaching your house often meant trouble was coming with them. Arthur, I said, stopping at his walkway. Pendleton, from the old Miller place. I know who you are, he said, setting his clippers down. Heard you had some excitement this morning. The neighborhood grapevine was clearly in full effect. You could call it that, I said. I'm sorry to bother you, but I need your help. I'm taking action against Brenda and the HOA. He physically recoiled. Oh, I don't want any part of that. I just want to be left alone. I know you do, Arthur, we all do. But Brenda won't allow that. Tell me, when she fined you for the wind chimes, did you appeal? He shook his head, looking at the ground. No. What's the point? She's the judge, jury, and executioner at those hearings. So you just paid it? Yes. Arthur, I said, my voice soft. I need to ask you a question. Did you happen to record that hearing, or any of your interactions with her? He looked up, his eyes wide with alarm. Why would I do that? Because you're a smart man, I said, and you knew you were being railroaded. Because you wanted a record, even if you were too afraid to use it. He stared at me for a long time. The fear in his eyes was warring with a flicker of something else. Hope, vindication. He licked his lips. Even if I had, he whispered, it would be an illegal recording. This is a 2-party consent state. I smiled. This was the moment. Not for OA meetings, Arthur. The state Supreme Court ruled on that 7 years ago. Franklin v. the Gables HOA. There is no reasonable expectation of privacy in a quasi-governmental meeting that you are required to attend as a condition of homeownership. Any member can record any official HOA meeting. Did you record the hearing where she fined you for the wind chimes? A slow smile spread across his face. It was like watching the sun rise. As a matter of fact, he said, his voice gaining strength, I believe I have an audio file of that entire meeting on my laptop. She was quite animated. Arthur Henderson, I said, returning his smile. I believe you and I are going to be very good friends. That evening, David sent me his preliminary report. It was beautiful. He had pulled the HOA's original articles of incorporation. He had their tax filings for the past 5 years. He had the minutes from every board meeting that had been publicly filed. And he had the bombshell. It was better than I could have hoped. I thought my ace in the hole was that my property was excluded. David had found something far more devastating. Brenda McNamara, president of the Creekwood Estates Homeowners Association, did not actually own her home. According to the county deed records, the house she lived in was owned by a trust based in Nevada. She wasn't the trustee. She wasn't a listed beneficiary. David had cross-referenced the property tax records. The bills were sent to a corporate services company in Reno. He did a quick search on her husband's name. Nothing. He did a search for rental registrations with the county. Nothing. The Creekwood Estates bylaws, which David had also helpfully attached, were crystal clear on this point. Article 3, Section 1. All members of the board of directors must be owners in good standing. To be an owner, you had to hold legal title to a property within the association. Brenda McNamara was, in all likelihood, a renter. And if she was a renter, she wasn't an owner. And if she wasn't an owner, she wasn't eligible to be on the board. And if she wasn't eligible to be on the board, every vote she had ever cast, every fine she had ever levied, every contract she had ever signed, and every meeting she had ever presided over as president for the past 5 years was null and void. She wasn't a queen with no clothes. She was a queen with no throne. I picked up the phone and called my lawyer. Not just any lawyer, I called Julian Croft, the toughest litigator I had ever faced in court. A shark. My shark. Julian, I said, it's Arthur Pendleton. I have a case for you, and you are going to love it. The final escalation came 2 days later. It was a masterpiece of panicked incompetence. A courier delivered a thick envelope to my door. Inside was a notice of emergency injunction and temporary restraining order. Brenda, through the HOA's terrified-looking general counsel, had filed a petition in Superior Court. She claimed my barn was in a state of imminent collapse and posed a grave and immediate danger to the children of the community. The petition was filled with hysterical, hyperbolic language. It included blurry, badly lit photographs of the barn taken from skewed angles, making the solid hemlock beams look warped. It included a 1-page expert report from an engineering firm I had never heard of, which stated, without any supporting data, that the structure was critically unstable. And it demanded the court grant the HOA immediate permission to enter my property and abate the nuisance by demolishing the barn. The hearing was set for the following Monday. She had made her final fatal mistake. She had taken our dispute out of the kangaroo court of the HOA and put it into a real one. A court of law, a court of evidence, my home turf. I spent the weekend with Julian and David, preparing. We didn't need to do much. The case was already made. We simply organized it for presentation. We compiled our own binders, copies for us, for the judge, and for the opposing counsel. We subpoenaed Deputy Miller. We prepared affidavits for Janice and Arthur Henderson. David, with his usual flair, had managed to get a sworn statement from the owner of the engineering firm Brenda had cited. It turned out to be a one-man operation run out of a strip mall. The engineer admitted under oath that he had never visited my property, had never inspected the barn, and had simply written the report based on what Ms. McNamara had told him over the phone. For a fee of $500, Julian was giddy. Arthur, this isn't a case, he said, pacing his office. This is a public execution. She's not just going to lose. She's going to be referred for criminal charges. Perjury, fraud. This is beautiful. The morning of the hearing, the courtroom was packed. Brenda had rallied her troops. One side of the gallery was filled with her supporters, a collection of stern-faced homeowners clutching copies of the HOA newsletter like holy texts. On my side sat Janice, looking nervous but resolute. Next to her was Arthur Henderson, who gave me a small, determined nod. Behind them were a dozen other residents of Creekwood Estates, people who had been fined, harassed, and humiliated by Brenda over the years. They had heard what was happening and had come to watch. Brenda sat at the plaintiff's table with a young, deeply uncomfortable-looking lawyer. She wore a severe navy blue suit, a costume of sober authority. She looked confident, serene even. She still believed she was in control. She still had no idea. The judge, a no-nonsense woman named Judge Carmichael, entered and the proceedings began. The HOA's lawyer stood up and began to lay out their case. He spoke of public safety, of community standards, of the board's fiduciary duty. He painted a picture of a stubborn, unreasonable old man hoarding a dangerous wreck in defiance of his neighbor's well-being. Then Brenda took the stand. It was a performance for the ages. Her voice trembled as she spoke of her fears for the neighborhood children. She dabbed at her eyes with a tissue as she described the creaks and groans she heard coming from the barn on windy nights, from her house, a quarter of a mile away. She presented the fraudulent engineer's report as gospel. Under her lawyer's gentle questioning, she swore, under oath, that the HOA had full jurisdiction over my property, that the barn was a clear violation, and that I was endangering the entire community. Then it was Julian's turn to cross-examine. He walked slowly toward the witness stand, a thin smile on his lips. "Miss McNamara," he began, his voice silky smooth. "You've testified that you are the president of the Creekwood Estates HOA. Yes, that's correct. And the HOA's bylaws require all board members to be owners in good standing, do they not?" "Yes. Mrs. McNamara, would you please state the address of the property you own within Creekwood Estates?" A flicker of panic in her eyes. "I live at 124 Chestnut Lane." "That's not what I asked," Julian said, his voice hardening slightly. "I asked for the address of the property you own. Let me rephrase. Do you, Brenda McNamara, hold legal title to the property at 124 Chestnut Lane?" The lawyer at her table shot to his feet. "Objection, Your Honor. Relevance?" "Overruled," Judge Carmichael said, her eyes fixed on Brenda. "Answer the question, Ms. McNamara." Brenda swallowed. It's a complicated ownership structure. It's in a trust." "Indeed it is," Julian said, pulling a document from his binder. "A trust based in Nevada." "Are you the trustee of that trust, Ms. McNamara?" "No." The word was barely a whisper. "Are you a listed beneficiary of that trust?" "No." "So, you are a renter, are you not?" The color drained from her face. Yes." A gasp went through the courtroom. Julian let the silence hang in the air for a moment. "So you have been serving as president of the HOA for 3 years, and on its board for 5, in direct violation of the association's own bylaws. Is that correct?" She didn't answer. She just stared blankly ahead. The mask was gone. There was nothing behind it. It was a rout. Julian didn't even need to be gentle. He presented the evidence, piece by methodical piece. The plat map showing my property's exclusion. The certified mail receipts proving she had been notified of the barn's historic status. The affidavit from Janice, detailing Brenda's willful disregard for legal advice. Deputy Miller's calm, damning testimony, corroborated by his body camera footage, which we played on a large screen for the court to see. The final nail was Arthur Henderson's audio recording. Julian played it over the courtroom speakers. Brenda's shrill voice filled the room. "I don't care if he calls it a historic landmark. It's an ugly piece of junk and it's coming down. We have the authority, and even if we don't, who's going to stop us?" Judge Carmichael listened to the entire thing without expression. When it was over, she took off her glasses and rubbed the bridge of her nose. She looked at Brenda's lawyer, who looked like he wanted the floor to swallow him whole. "Counsel," the judge said, her voice dripping with ice, "is there any reason I shouldn't dismiss this petition with prejudice and sanction both you and your client for filing a frivolous, bad-faith action?" The lawyer just shook his head. "And is there any reason," she continued, her gaze shifting to a stunned Brenda, "that I shouldn't refer this entire matter to the Attorney General's office for investigation into perjury, fraud, and violations of the State Historic Preservation Act?" The collapse was total. Brenda seemed to shrink in her chair, all the bluster and arrogance gone, replaced by a hollow, vacant stare. She had flown too close to the sun, and her wax wings, built of lies and intimidation, had melted completely. The verdict was swift and brutal. The injunction was dismissed. The judge issued a blistering ruling from the bench, calling the HOA's actions a shocking abuse of power based on a foundation of deceit. She ordered the HOA to pay for all of my legal fees, and as promised, she formally referred Brenda McNamara's conduct to the state attorney general and the local district attorney for criminal investigation. The aftermath was a cleansing fire. The HOA board convened an actual emergency meeting that night. Brenda was summarily removed from her non-existent position. The two board members who had voted with her resigned in disgrace. Janice was appointed interim president. Her first act was to propose a full audit of the HOA's finances and a review of every fine levied under Brenda's tenure. My lawsuit against the HOA and Brenda personally was filed the next day. The HOA's insurance carrier, faced with the mountain of evidence and the judge's ruling, settled within a week. The settlement covered all my costs, plus a substantial six-figure sum for damages which I quietly donated to the State Historical Society. Brenda, whose actions were deemed intentional and fraudulent, was not covered by the insurance. Faced with my lawsuit and the impending criminal charges, she and her husband broke their lease and disappeared in the middle of the night. Her reign was over. The community began to heal. Under Janice's leadership, the board rescinded dozens of absurd rules. They refunded thousands of dollars in unjust fines. Arthur Henderson's garden gnomes returned to their rightful place. The neighborhood started to feel less like a police state and more like a community. People started talking to each other again, not in hushed whispers, but in friendly greetings. A few weeks later, I was sitting on my porch swing, a glass of iced tea in my hand, watching the sun set behind the silhouette of my barn. It stood tall and proud, a silent monument to endurance. Arthur Henderson walked up my path holding 2 beers. He handed one to me. "Figured you could use one of these," he said, sitting in the wicker chair opposite me. "Thank you, Arthur," I said. We sat in comfortable silence for a while, just watching the colors of the sky change. "You know," he said finally, "for 5 years I was terrified of that woman. I just wanted to be left alone, but I thought the only way was to keep my head down and do what she said." "It's a common mistake," I said, "but bullies don't want you to be left alone. They want you to be compliant." "You weren't afraid," he said. "Not once. I considered that." "I wasn't afraid of her," I clarified. "I was afraid of what she represented. The idea that rules don't matter, that facts are optional, that the loudest voice wins. My entire professional life was built on the principle that that isn't true, that on paper, in the records, there is a truth that can't be shouted down." I took a sip of my beer. I didn't fight her because she threatened my barn. I fought her because she threatened that principle. We finished our beers as the last light faded from the sky. The next day, a small package arrived. It was from Julian. Inside was a simple wooden frame. In it was a single sheet of paper, a copy of the first page of Judge Carmichael's ruling, the part where she called Brenda's case a shocking abuse of power. Taped to the glass was a sticky note from Julian. It just said, "Reese." I hung it on the wall in my office, right next to a photograph of Eleanor standing proudly in the doorway of the newly restored barn. It was a reminder that peace is not the absence of conflict, but the presence of justice, and that justice sometimes requires patience, preparation, and a whole lot of paper. The barn was safe. The neighborhood was quiet. Order was restored. It was a good feeling. It was the feeling of a file, finally and definitively closed.